For decades, business owners relied on a core assumption. Incorporating a private company meant keeping the capitalization table strictly out of the public eye. That privacy is gone. A global regulatory push against money laundering has shattered the legal firewall that once shielded the owners of private Canadian corporations. Federal and provincial statutes now codify beneficial ownership transparency as a rigid, active mandate. Legal practitioners must now inform clients who expected complete privacy that their ownership details are subject to mandatory government filing. Relying on old assumptions about the corporate veil leads directly to regulatory penalties and a significant shift in professional risk management. The trap lies in the fragmented rollout of two overlapping statutes, the Canada Business Corporations Act, the CBCA, and the British Columbia Business Corporations Act. Under the federal CBCA, the public registry is active. It went live January 22, 2024. Under the provincial BCBCA, companies currently hold these registers internally, but that ends fall 2025 when BC launches its own searchable public registry. A client operating a mixed corporate structure, holding stakes in both federal and provincial entities, faces a staggered, highly confusing timeline for public exposure. This fragmented legislative landscape attaches strategic liability to routine minute book management. To navigate this, practitioners must determine the exact statutory trigger, identifying precisely who gets reported to the government. The federal statute designates these people as an individual with significant control, or ISC. British Columbia calls them a significant individual. This pie chart shows the primary threshold. Any individual holding 25% or more of the company's shares is immediately captured by the statute. The secondary trigger applies to voting power. Holding 25% or more of the voting rights activates the exact same mandatory reporting. These thresholds apply directly and indirectly. They capture silent partners, complex trust arrangements, and multi-layered holding company structures. The mandate cuts past the named directors and officers to target the actual, ultimate beneficial owners. Hitting either the share or the voting threshold instantly strips a fractional owner of their anonymity and triggers mandatory public disclosure. Historically, failing to maintain a pristine minute book carried negligible real-world consequences for private companies. The 2024 amendments to the CBCA establish new, inescapable filing obligations for private federal corporations. These companies must now proactively file their ISC register with Corporations Canada on an annual basis, upon incorporation, and within 15 days of any internal update. The statute dictates a specific, severe penalty for any corporation failing to comply with these exact filing requirements. Upon summary conviction, a non-compliant corporation faces a fine of up to $100,000. A six-figure penalty alters the entire risk profile of corporate record-keeping, demanding rigorous, proactive enforcement by legal counsel. Practitioners now face the practical nightmare of extracting sensitive personal data from reluctant shareholders across misaligned jurisdictions. This graphic compares the exact data requirements. We start with the personal information demanded by the federal CBCA on the left. Federal law requires the individual's residential address, their address for service, and their citizenship. Now look at the provincial BCBCA on the right, which demands an overlapping but distinct set of data. BC mandates the collection of the last known address, citizenship, or permanent resident status, and crucially, the jurisdiction of residence for tax purposes. This specific requirement forces friction with clients, many of whom fiercely protect their tax residency information from public exposure. Using a generic one-size-fits-all shareholder intake form guarantees statutory non-compliance in at least one jurisdiction. The data requests must be perfectly tailored to the incorporating statute. Clients will inevitably resist this level of exposure, citing extreme privacy concerns and even physical safety. The statutes offer very narrow relief. Under the CBCA, there is a minor exemption. The director will automatically withhold information from the public registry for any individual under 18 years of age. For adults, the individual or corporation must formally apply to the director to suppress the data. A process that requires proving public disclosure presents a serious threat to the individual's safety. Beyond collecting the data, corporations are now strictly liable for how long they keep it. The 6-year retention rule dictates that a corporation must securely dispose of a former owner's personal information exactly 1 year after the 6th anniversary of the day they cease to have significant control. However, this disposal requirement remains subject to any overriding provincial or federal laws that mandate a longer retention period. Private corporations are now forced to operate as secured data custodians for highly sensitive personal information, adding a permanent layer of operational risk. For practitioners dealing with British Columbia companies, the timeline for strategic action is accelerating rapidly. BC private companies are already legally obligated to maintain a transparency register at their physical records office today. In fall 2025, that requirement shifts from updating a private internal document to submitting a mandatory online filing with the BC Business Registry. This activates a critical, continuous compliance mechanism known as the 15-day rule. Any change in significant control, whether through a share transfer, a death, or a corporate reorganization, must be recorded and filed within exactly 15 days of the company becoming aware of it. Compliance is no longer a passive, end-of-year administrative check-in. It requires real-time, active monitoring of all cap table movements. The transition from private, closed-door record-keeping to public beneficial ownership registries is permanent. Companies face severe, 6-figure financial penalties for failing to execute the relatively simple act of proactive data collection. Legal professionals must immediately audit their clients' corporate structures, identifying exact statutory exposures across differing federal and British Columbia rules. Mastering corporate transparency is a primary pillar of modern corporate legal practice. Advising clients proactively today is the only way to prevent massive liabilities tomorrow.